We are at day 9 for the defense's case, and the defense had given 5 issues for the judge to look into so Brian Walshe could testify. And we begin off with the defense won't be calling Brian Walshe. The judge points out, does that make moot the 5 issues she researched last night? Yeah. And the defense will actually call no witnesses. The judge actually explains a sidebar ruling that happened previously to, the court, to the public. The jury's not in there yet. The Commonwealth asked the court to exclude his plea of guilty. The judge put it on the record she didn't let that come in. She did it because the defendant hasn't shown how that's relevant to the remaining charge of murder. The defense submitted a document this morning that, according to the judge, didn't help their case. Could be that they're basically like, hey, if we can't mention the fact that he pled guilty to those 2 crimes, then it's not worth him testifying. Defense opening made it appear Brian would testify, and he could have made reference to his plea if the judge allowed it, but the pleas are irrelevant if he murdered his wife. That's a separate charge. These would be extraneous factors for the jury. It's possible the jury would consider this sentencing of his guilty pleas that have already happened and take that into account, and that's not okay. There was another filed document to stop the guilty plea coming in. That's moot. Motion to prevent Commonwealth from saying defense promised something in opening that they couldn't deliver, and the Commonwealth can get into that in a little bit. So basically, the defense is wanting to say that they argued that it was sudden death, and they want to prevent the Commonwealth from focusing on the fact that Brian didn't testify and that there's like they couldn't prove the defense's case, basically, which there's a colloquy with Brian Walshe. If requested, she can tell the jury he has a right not to testify and they can't hold it against him. Brian has to say he isn't on alcohol or substances. Nobody's threatened him. His decision is his own to not testify. The jury's brought in. Defense rests. Sidebar. The judge addresses the jury. All evidence has been submitted. The defense has no burden in this case. She needs to give the jury legal instruction for the closing arguments. That'll all happen tomorrow. There'll be instructions, argument, instruction, and the jury is sent home. There's discussion about Jem's testimony. A document needs to be submitted for identification. It's the police interview that he gave, and the defense will get that submitted. So the jury is going to get that interview where Jem was saying he couldn't remember things. Well, the jury is going to get to see it, right? Charge conference starts. Talk of the instructions for the jury. The state asks for a brief break, and the judge says draft instructions include italics for instructions she wasn't sure what she wanted. Like the defense saying the object of the killing must be a human being. She doesn't understand why that's in there. Talk of the judge trying to fairly talk of Brian's prior bad acts. I expected personally both of the closers to be women for the case because, I mean, to me that made sense, I guess, because the victim's a woman. So if the defense and the state, maybe it has a little bit more impact on some of the jurors. But while the state's using a woman, the defense will be using the same man that gave the opening. Defense is seeking instruction on defendant's right to not testify, and the Commonwealth is seeking a motive instruction. The judge is going to look over the instructions. The state wants talk of conscience of guilt instruction. She wants to use the wording of some evidence suggesting. Defense apologizes for the object of the killing being a human. That was included. Wasn't meant to be, I guess. They say they will return at 10:30, and it was a little later than that. And the state asked to see the cases the judge looked at, and then we're back. So it was very quick. Well, not very quick, but we're back. The state has an issue on page 15, but defense also has an issue on page 1. Shocked the judge because page 1 is the index, and they meant paragraph 1, which is on page 6. The defense renews request for that section about the timing of premeditation be removed. Judge refuses the request, but understands the argument. Saves that for the appeals court. So there's something going to be said to the jury about the timing of premeditation that the defense didn't want in there. Talk of dangerous weapon instruction because there's no evidence of a weapon killing on a Walshe. The jury shouldn't speculate a weapon was involved without sufficient evidence. State says reasonable inference because he searched how to clean a knife, and he went to the liquor store dumpster before the trip to Lowe's and things for cleanup. So they're kind of putting, well, what is he throwing away Could it be a knife he used? Um, I have a note here that I put in at this time. Personally, here, before I get into both sides' arguments, I have a note. I get where both sides are coming from. That knife in the kitchen that we actually had never had actual testing other than that preliminary test, which was just could be from vegetables, right? They never did, from my understanding, from my recollection, an actual test for the blood and identifying what's on it. None of that happened. So I get where the defense is coming from. There isn't a murder weapon. There is, and the thing is, there might not be a weapon per se. Like, even if Brian Walshe killed her, it could have been strangulation. So I don't see how mentioning a weapon is required to prove the Commonwealth's case, right? The judge asked if search with dishwasher was specific about the knife. Talk about the article he looked at, removing DNA from a knife. Then does a dishwasher clean blood? Is it possible the knife is contaminated with HIV after being positive after being washed? Trip to the liquor stores before Lowe's, and Brian did searches on dismemberment. So they're saying that he went to the liquor store to throw something away before. Again, defense can make the argument whatever they want. Maybe Anna died. Maybe he transferred the body. There's blood, maybe from him injuring himself, trying to like move her down the stairs or wherever they. I don't know how they'll go into it, but there are arguments that could be made if the defense wants to go there. Theoretical, why he went to the liquor store, what there would be to throw away. Um, if they're allowed to go into that direction. Defense asks for part of the instruction. The jury doesn't get a broad instruction to speculate because anything could have been a weapon. Defense will send possible language, and this judge says that it's going to be, they're going to be allowed to say it in some way. Page 15, the state want to talk about impeachment by prior conviction. It includes language seeming to be about someone testifying. The judge thinks it should be out, the defense thinks it should be out, and the whole section is just coming out. State wants to include the lying and dismemberment as prior bad acts. The judge asked, where is the line? What about lying to his federal probation officer? Defense said they tried to answer this. The jury has to know he isn't charged with those things. They can only use them for a limited purpose. The jury will probably be asking themselves, that's a bad thing to do if they believe he dismembered the body. And if they believe it was disposed of in bags, they will think of that as a bad act. They need to think that they can only use it for a limited purpose in these charges. The defense originally meant for the art fraud, but he suggests use the art fraud stuff they submitted for all the bad acts. Defendant hasn't been charged with any other crimes than murder in this case, because remember, he pled guilty to the others. The judge thinks that should come in, maybe change to only charge to consider is murder. The judge suggests listing they have heard evidence of the art fraud, lying to police, dismemberment, and lying to probation officer, but it is unfair to consider this evidence for the purposes of the murder charge. Judge doesn't want to include defense's last two lines, whatever they are, but the defense argues those are from the model instruction, and the judge says she has an issue with saying what she already said and that as well. I mean, we're going off the instructions here. Could be an appellate issue. State says they could be giving jury conflicting instructions on consciousness of guilt, and the judge is going to shift things around to hopefully help that out. Both sides have a problem with page 27. State wants it changed to try to conceal the disposal of Anna Walsh's body to concealing the body itself. So basically, the wording is concealing the disposal, and the state wants it to be concealing the body. Defense wanted to try to dispose of the whole thing, but the judge one that tried to dispose instead of disposed. Judges against it. Commonwealth wants attempts to provide false information. So yeah, basically we're fighting over how things are just going to be worded to the jury. Little bits in there because remember, the defense's case is going to be rough. There's a lot of evidence that he killed her. Is it enough though? The defense wants more context for the jury on how to apply consciousness of guilt. The judge will move things around to decide later. The court does not plan to give the jury physical instructions while reading them the instructions. The state wants mention of circumstantial evidence to be directly mentioned, and the judge says indirect sometimes. She'll say it's indirect evidence, sometimes called circumstantial. And then we get some interesting things. The judge wants to talk about the line being drawn in the closing arguments. She lists a bunch of case law. This is about improper burden shifting in the closing argument. The Commonwealth shouldn't say the defendant didn't testify, but they should be able to say there's no evidence Anna Walshe died of natural causes. Judge tells the defense there is no testimony tying sudden unexpected death to Anna Walshe. Defense says the state is arguing a cause of death being homicide without evidence, so it should be fair game for the defense to make an equally consistent argument. The judge says the state's met their burden. And the defense says the state's own medical examiner said death can happen suddenly to healthy people. The Commonwealth has no direct evidence of homicide, so the defense should be able to argue sudden death. There was no objection to the sudden death testimony, so that's all before the jury. The judge presumes the state will suggest some evidence in the trash will be from before the dismemberment and the death. The judge is asking for the defense's circumstantial evidence that she died of sudden death. So the judge is asking the defense, where's your evidence? Defense says all the evidence of a homicide could be evidence of a person acting out of fear after someone died of a sudden death. Commonwealth doesn't want the burden shift from their opening statement and will question the sudden death testimony. So basically, the Commonwealth is saying, look, we're not going to mention the fact that Brian Walshe didn't testify, but we're going in on the sudden death. The judge says the two sides need to talk to each other. Judge says to look at the verdict slip, 45 minutes for each side for closing, but the judge won't cut them off, and does mention 45 minutes is about all a jury can take. I will say, having watched many trials, that after about 45 minutes, it takes a toll in the closing and openings, the closings from both sides, and then it's over. So that's it for the day. So basically, the position we're at is the defense is going to try to argue in the closing that Anna Walshe suddenly died, Brian panicked, didn't know what to do, and all of the evidence only can be proving to that. The state seems to be focusing, if they want to prove a killing, there could be more, but what we've got today is their focus is going to be on the knife, the searches about knives, and that liquor store trip. And I guess the question to you is, if you only had those searches and you only had the liquor store trip, is that enough for you to convict for murder? Because the defense is going to argue that everything after that was a cover-up, right? Of a natural death. And then they might even make arguments for what could have been, because we don't know what was thrown away at that liquor store. And of course, the defense, they might go, they might not. They could mention I think they're allowed to mention other hypotheticals. They could ask, has the state proven that Brian Walshe's mother wasn't there? Brian Walshe's mother, we have testimony that she was angry at Anna, that she was angry after Anna disappeared. And Brian did tell his probation officer his mother was with him. Did the mother do it? I don't know if they'll go that direction, but there's a lot of different things that this could happen. Again, 45 minutes isn't a long time. So with all this said, what is my plan for tomorrow? Well, as I've told you for a while, I didn't want any surprises. I have something I have to do tomorrow. I have a lot of things I have to do tomorrow. I have to finish getting my new phone, hopefully. I have other stuff. I am going to try to get a video out in a reasonable time on this case tomorrow and get something out after the jury instructions. If I can't, due to time constraints, basically time constraints are going to matter. There might be a video that just goes up to the closing arguments. There might be a video that goes all the way through to the jury instructions. There might be no video until the weekend. So just fully transparent. That's how my luck works. Whenever there's something important happening, everything happens at once. So I'll do my best to get that out. But very surprising, I think, for me. I really thought he would testify because I feel like he needed to testify to try to solidify his defense. But maybe the defense side has decided we can have a more open-ended what ifs. It doesn't actually prove anything closing argument without Brian being locked into a story. We're just going to have to see.